Hello everyone. Very good afternoon to my all CA colleagues. Today we have a speaker named CA Pankaj Shah sir. Let me introduce him first. CA Pankaj Shah is a distinguished chartered accountant with a proven track record of excellence in direct tax litigation and business restructuring. He holds multiple qualifications including FCA, CS, BBA, LLB honors, insolvency professional, and registered valuer, which give him a unique blend of financial, legal, and business acumen. He is a Central Council member of ICAI and serving in various standing and non-standing committees of Institute. CA Pankaj Shah has delivered over 1,000 technical seminars showcasing his excellent communication and presentation skills, which have helped him to establish himself as a renowned expert in this field. He has authored many articles in ICAI journals, AIFTP journals, and is an editor of ITJ magazine. As a direct tax litigation and restructuring specialist, CA Pankaj Shah has assisted numerous clients in resolving complex tax issues and disputes, helping them to optimize their tax position and achieve their business goals. His broad ranging expertise in legal, financial, and business matters allows him to provide strategic and holistic advice to his clients, making him a trusted advisor to many. His diverse skill set and a passion for delivering quality services have earned him an inviolable reputation in this profession, making him one of the most sought after professional. So please join your hands and welcome CA Pankaj Shah with me, CA Vrinda Vakharia, Chairperson of Baruch branch. Now the session is yours, sir.
Very good evening. At the outset, I am thankful to the Direct Tax Committee for providing this opportunity to discuss on powerful representation in this faceless regime. Let me just share my presentation with all of you. Yeah, I think it is visible to you all. Uh, Today's topic is powerful representation in faceless regime. Why powerful? See, earlier we had face-to-face communication. And in that face-to-face communication, we were able to explain our case merits to the departmental officer. We could explain him, we could read his mind. But now, since that facade is there in between us, there is a faceless regime. So how to make an impact to get the maximum success in our representation assignments? I have brought various techniques, various tips before you, based on which we can achieve maximum success in our litigation appeals. We can minimize and mitigate the impact on our clients in faceless regime. At the outset, let me appreciate the efforts of government in bringing this faceless regime. This has provided a level playing field to all the young members as well as senior members. Everybody can now represent sitting in their offices. Now, gone are the times when we had to wait before the assessing officer's cabin, income tax officer's cabin, and wait for our turn to come. Then how much time he used to give it to us? Some things they would refuse, that we will not take this on record. All those things have gone now. Whatever you want, earlier we had to be very cautious. Oh, if we write this language, the officer may feel offended. But nothing like that now. Whatever we want, we can write as per our free will. There is no issue of any ego issues, because neither the officer knows us nor we know the officer. So everything is faceless. The only problem which is coming is in appeals, that there is hardly any disposal since last 5 years. But government and our institute is bent upon, we are making representations. There have been many writs filed in High Court requesting the government to expedite the disposal of appeals. There have been two Vivad Se Vishwas schemes, direct tax dispute resolution schemes, but still lot is to be done. So in this regime, when we are appearing before the assessing officer, when we are appearing before the appellate officer, how do we represent our case in the strongest manner is what we will discuss it today. My topic itself is powerful representation in faceless regime. See, let's see where we all have to represent. in the assessment proceedings, in the reassessment proceedings. There are show cause in the assessment or reassessment proceedings. There are adjudication proceedings. The assessing officer will decide. Then there is an order. Against that order, we will go into appeal. Then simultaneous penalty proceedings will get initiated. In penalty, we have to explain that we have given full and adequate disclosure, and there is no underreporting or misreporting, or the charge has to be clearly specified. Many times what happens, the assessing officer may not clearly specify charge, that what fault is there with the assessee. If he is not able to clearly specify the charge, that itself is fatal to the penalty proceedings. We will be discussing all these things. Then comes recovery proceedings. See, recovery is a balancing place, because assessee has a demand, but he has difficulty in paying since he has a prima facie case. On the other hand, department needs funds to run the country. There is a cost to exchequer, which is to be met by the recovery proceedings. So balance is to be stricken. Yes, yes. Oh, okay. Sorry, my PPT is was shared. Start podcast. Yeah, is it now visible? Yeah, okay. Thank you very much. So my topic, powerful representation. This was all about proceedings, which we are going to discuss it today. Now, moving ahead, see, there will be four P's which we will be discussing. First is presentation. How do you draft? Because your draft is your face now. Whatever you draft will show that how expert you are and how better you are able to present. In that drafting comes pleading. How do you plead your case? How do you present your facts? How do you present your legal contentions? Then persuasion. You may find that the officer is not satisfied with your one limb of argument, so you have to persuade it. You have to see, many times when it happens before a court, so then you have to see if the judge is not convinced. You may believe that it is not your day, and you may avoid the hearing to conclude. In the next hearing, maybe there is a different mindset, and your arguments may appeal to the authority. So persuasion is also very important. And then precedents. What is the law? What are the judicial pronouncements? This is also very important aspect in this powerful representation. So our powerful presentation will be by presentation, pleading, persuasion, and precedents. Now, with this background, let me introduce you to this gentleman. I think we all must be knowing him, Nani Palkiwala. He was the most sort of the advocate in the country. He has been a legendary lawyer who has safeguarded our constitution. When he used to represent in court, he has appeared before numerous authorities, ITAT to Supreme Court. And when he used to argue a case, it is said that Palkiwala used to look into the eyes of judges and dominate their brain. The way he used to represent, they used to feel whatever Mr. Palkiwala is saying is only correct, rest all is something which is useless. So that was the way he used to present the case. So when we are making a presentation now in writing in this faceless regime, it should hammer on the minds of the assessing officer or reading authority. It should be very clearly stated. Our representation should be in such a manner, a chronological manner, in proper description way, so that the officer gets convinced, satisfied with it. How to do it? So let's start. Well, begin is half done. So when we start presentation, we have to make choice of some fonts. When you start a new word file, which font do you get? Either it is Cambria or Calibri, but both are not suitable for a legal drafting. When you are making a legal drafting, either Times New Roman, which is age-old font we all know. Second, my favorite font, my personal choice is Verdana. This Verdana is the font which makes readability percentage higher. So when something is written in Verdana, you are able to read it better, and there is an impact because of this font itself. Whenever you read any decisions, many decisions are in the font Georgia. So these three fonts are advisable. My personal choice is about Verdana font. Then, why do we become miser in giving spacing? See, at least 1.5 or double spacing should be there whenever we make a written submission. You all must be aware that High Court decisions or Supreme Court decisions, whenever you see any decision, you open the court copy, court order copy, you will always find that there is a double spacing. Why there is a double spacing? Which makes readability better. So, if you are having a better readability in your representation, automatically it will make an impact on the assessing officer. Similarly, on the client also, just imagine you are showing one page small letter to your client that this is submission I have made, and you show it him a 10 pages draft. Automatically he will be convinced by your draft that nay, better representation has been made in my case, and he will not avoid making payment of fees. So all this is how do you present your case before the authorities as well as before the client. One advice which I give in all the representation matters to my fellow chartered accountants is, whenever you make a draft, whenever you make some submissions, get it physically signed by your client so that he knows what you are representing. Otherwise, you may put in so much efforts, but unless the other authority, other person, the end user comes to know what efforts you have given, he will never appreciate. So it is always you have to do it and you have to show what you have done. Then only we will be able to encash our representation skills. Then, whenever you are making a presentation, see, if anybody has been to Supreme Court, in Supreme Court, there is a very important practice. There is advocate on record, and that advocate on record is required to ensure that there is a list of dates there. You have to give any document in proper referencing. There has to be a systematic format. Who is the assessee? What is his PAN number? Which assessment year this submission pertains to? What is the DIN number? What is the subject matter, whether it is reply to AO or assessment proceeding or penalty proceeding. So subject should also come very clearly. So all these referencing aspects are there. And I would suggest that whenever we are dealing with a case, whenever we are making submissions, either in assessment or appeals, we should ensure to have a list of dates, chronological date of event, list of events before us. That is very helpful, because what is the date of 148 notice, for example? What is the date of order? When it has been served to us? If this kind of chronological list is there, we will be able to decipher if there is a time barred assessment or the notice is beyond the limitation period. There are various technical defenses also available to us, which we will be able to check only if we have a list of dates and chronological order sheet before us. If my senior friends have joined, they would appreciate, in olden days, whenever we used to go into assessment or appeal proceedings, an order sheet was maintained by the AO or appellate authority, wherein on the left side of file, a green paper used to be stick, and he used to record our hearing and get our sign. So that was a sequence of events, how it has flown. Why don't we make our own order sheet? Then when the client referred the case to us, when did he submit the details called, when we called about the details, what is the hearing, what happened on the date of hearing, whether we sought adjournment or we have submitted a prima facie reply. So this kind of order sheet, if they're with us, that would be very helpful. One more important thing which I have observed, that in this representation regime now under Faceless, many times we don't get notices from our client. Our client has given some old email ID and he's not accessing that mail ID, and notices are coming, but we are not aware. So the possibility of an ex parte order increases. Now, friends, there are various tools and softwares which are coming. These softwares are very helpful. If you put the PAN number and the password in that software, that will give you list of notices. Whenever new notice is issued in case of your client, you will get an alert about that notice. So these kind of notice alert softwares and tools are very useful, so that there are no ex parte orders, because it is very much possible that our client may not inform us. He himself is not aware that some new notice has come. So we can use this kind of software if we have a good appellate practice, so that we get informed about every new notice coming to our appellate client. Now, this was how to give a presentation, how should be our draft formatted. It should be either 1.5 or double spacing, and Verdana font should be there. Font size should be 12 for the content and 14 for the heading. This is really making good impact, because well begin is half done. Now, when you are making a powerful presentation before the officer, what all should be there in your draft? First, facts should be there. What do you mean by facts? See, facts are very important because it is said, marshal the facts, law shall follow. I'll share a personal advice to my friends. Whenever you are reading or making a representation, you have an order before us. Friends, do read that order at least 3 times and at 3 different times, because at different times we are in different state of mind. And mind you, every time you read, you will find out something new and something interesting from that draft and order. So do read the order at least 3 times or notice 3 times when you are making an appeal or submissions. That will really help you. You have to do a threadbare analysis of facts, because facts is something which is most important. And whenever you find that the assessing officer has quoted something wrong or a wrong fact has been cited, please file an affidavit stating that this wrong fact has been stated in the assessment order, and file that affidavit along with your written submissions. That is very important whenever the assessing officer gives some wrong fact or wrong information. I'll share a very interesting scenario. Once there was an appeal going on in a Bombay High Court, and the departmental appeal was there. So department representative read the order, advocate of department read the order, judge also read with him. Then when Mr. R.J. Kola, who was a very senior advocate by that time, when he argued, he started reading the same facts again. Judge said, "What, Mr. Kola? We have already read it. Why are you reading it again?" Well, no, Your Honor. My friend, the department representative, has read the order in his way. You have read it in your way. Now I will read it in my way. What is my way? I know where to lay emphasis, what to read fast. See, it is very important. You read everything, you don't hide anything, but where you should give emphasis is very important. So, whenever the assessing officer may write anything, when you are making submissions, you also reproduce the part of assessing orders, facts, and observation. And whenever you are feeling that these lines are important, do highlight them, give underlining, or provide emphasis on that, so that the officer, the adjudicating appellate authority, realizes that these facts should be referred, these are important. So same facts can be read in different ways by different persons. So we should always ensure that we put facts in our perspective. Our point of view is very important. So facts are facts, they will remain same. But what facts are more important and what are less important, that we have to demonstrate, and there lies our skills. Friends, there was an old saying that if you are good on facts, argue on facts. If you are not good on facts, argue on law. And when facts and law both do not support you, argue on constitution. So this is also very important. How do we argue? So when facts are complete, then come to law. How does law help us? Friends, nowadays, if you see any reassessment, majority reassessment issues are there. There are various defaults and defects as far as law is concerned. I'll give you one example. Last year, many notices were received by assessees who have given some kind of political donation to a party. Now, interestingly, income tax law is same for everyone in this country, India. In Gujarat and Maharashtra, the assessing officer issued a notice under 148 directly because there was a search on that 23 political parties. In other states like Madhya Pradesh and others, Uttar Pradesh, the assessing officer issued a 148A notice, show cause notice, and we are asked to file reply. And on the basis of reply, 148 was issued after 31st March because of the extended timeline. Now, friends, either 148 will be issued or 148A. It cannot be that 148 is valid, so 148A would not be valid. So, important thing is that there are different views and both views cannot be correct. One is correct, one is wrong. So these technical fine prints are very important. Then, if the order is pursuant to a search, there is a search in some third party. Based on that search, some notice is issued because our name is found in that search documents. So if the search is before 1421, the assessing officer still issues a notice under section 148 of the Act. That is not correct. That is wrong, because the notice ought to have been issued under section 153C. So there is a jurisdictional error. The jurisdictional notice itself is wrong. So because of this aspect, the whole order, the proceedings may become null and void. Then we all must be aware that there was a circular issued on 29th March 2022. In that circular, it was stated that now onwards, whatever 148 notices are issued, they will be issued by the faceless assessing officer, not by the jurisdictional assessing officer. But in spite of this circular, we have seen plethora, deluge of notices issued under section 148 of the Act by the jurisdictional assessing officer and not by the faceless assessing officer. Friends, Bombay High Court in the case of Hexaware has given beautiful findings and discussion. Telangana High Court decision is also there. Though these decisions are now pending before Supreme Court, department has gone to Supreme Court, but we must take this argument in our submissions that the notice ought to have been issued by the faceless AO. However, it is issued by the jurisdictional AO. So based on the Bombay High Court decision in the case of Hexaware, this notice and the consequent proceedings are null and void. Next, if notice is issued in the name of a deceased person, see, the notice can never be issued to a non-existent person. There must be some person. Yes, it can happen that when the notice is issued, the person was alive, and before completion of proceeding, he may expire. In that case, the proceedings are valid. You just have to substitute the legal heir in place of that deceased person. But when the original notice itself is issued to a person who is no more, then the proceedings are null and void. We may not appreciate it. Department, there are various decisions, even Supreme Court decisions are there, that whenever a notice is issued to a deceased person, which is many times seen in case of 148 proceedings, then the notice is null and void. Then, friends, 148 notice requires us to file return of income. Now, last to last year, there was a change in timeline. At least 90 days ought to be provided to file the return in response to the notice under section 148 of the Act. But what has happened? The assessing officer missed it and they continued writing 30 days in many notices issued. So, friends, whenever you see that 148 notice after the amendment still provides for 30 days, then that is depriving us from a right which has been conferred by the legislature to us. That is violation of natural justice, and that would not survive. So, friends, in this case, I would suggest that we should technically challenge the validity of notice, that it is void, it is beyond jurisdiction, because it is depriving us from the opportunity of natural justice and a legal condition, legal right which is vested on us to file the return within 90 days. Then, friends, my old and senior members would appreciate that when we used to go to department, there was a ward and there is a circle. Assessing officer, ITO was there in ward, and above 15 lakh, if the return income is there, that case used to go to the assistant commissioner, which was in circle. In many notices, it is seen that where the jurisdiction was there with the assistant commissioner, my return income is more than 15 lakh, still the notice is issued from ward by the income tax officer. So that jurisdictional officer has not issued a notice. Normally, only an officer who has jurisdiction over your pen can issue a notice to you. So this is again a defect in law, which is seen in many cases. Friends, 148 issued between 1/4/2021 to 30th June. There was first round of litigation. Ashish Agrawal's case came. Supreme Court gave a new life with some condition. In the second round, the case again went to Supreme Court. Then there was a decision of Rajiv Bansal, which gave a theory of surviving period. This surviving period theory is very useful if there is a reopening of assessment for AY 13-14, 14-15, or 15-16. So 13-14 to 15-16, these 3 years, if your case is pertaining to, this Rajiv Bansal decision of surviving period theory can be very helpful in your case. Then, when we see the notice is accompanied by an approval, because see, issuance of notice is an extraordinary event, so there has to be authorization. Who will authorize? So there is an authority in law who can only authorize. If you have taken a higher authorization, for example, it should have been authorized by joint commissioner, but you have taken the permission of commissioner, that is also invalid. And wherever the law provided that you should have a permission of chief commissioner, and you have taken out joint commissioner, still the approval is invalid and consequent issue of notice is invalid. Then, how has he approved? So what has he written? It should be a speaking approval. The authority cannot write yes, approved. There has to be a reason. Okay, I have gone through the facts and I find so and so. So there has to be a speaking order for approval also. So this is important. Then friends, many times the assessing officer now are issuing notices through system. So they are directly sending the mails, but who has to sign it? See, whenever we file a return, we upload the return, but if it is not verified or e-verified, they make it invalid. Similarly, if the notice is issued and it is not authenticated physically or digitally signed by the AO, it becomes null and void. So that authentication signature is also very important. Then, friends, we all must have heard about the statement of our Honorable Finance Minister given, where she said that if you find a single notice without document identification number, DIN number, then you just tear it and throw it in the dustbin. Friends, DIN number is mandatory. Yes, there were many decisions, for example, Tata and other Brandex, which said that if there is no DIN, the notice is null and void and the proceedings are void ab initio. Against these High Court decisions, Department has gone to Supreme Court and Supreme Court has given a stay. But we never know whenever the decision comes, so we should always raise this objection technical P if there is no DIN or the DIN is generated after the issue of order, there is a post facto DIN, all these things will not sustain. So we need to appreciate that DIN is there. Then issue of notice. Friends, whenever there is the issue of notice, you have to see how and when it is considered as issued. Merely uploading on portal, whether would be considered as issue or not. No, friends, it will not be considered as an issue because whose portal is it? Mine. If I put some money in my own pocket, I have not given it to you. It will be considered as given when I take out and give it to you so that I cannot take it back. Similarly, whenever there is a issue of notice, you have to either send it through email, through SMS, or physically, but you have to send it. It should go beyond the control of originator, then only it will be considered as an issue. Then there are various cardinal principles in law. If 148 notice is there, there should not be any change of opinion, no new information, and all this. So, facts and law, these two aspects, how to represent powerfully, I have discussed. Then, friends, when this faceless mechanism came, the department also brought a taxpayer charter. Before going to this, there is a decision of Reuters which specifically says that if the assessment order is not signed, if the notice is not signed, it is not merely a procedural formality and the notice will be null and void. We may ask for an opportunity of video conferencing. If it is not given to us, that is a violation of natural justice and the matter may be remanded back by the to the assessing officer again. So now coming to taxpayer charter. Taxpayer charter, what is it? We will be discussing it. Uh, Before coming to taxpayer charter, just let me see if, yes, this is the taxpayer charter. This para I have specifically drafted. Why? Because with great power comes great responsibility. Department has been given now power to read and decide all the facts on the basis of your facts available on your portal. So this taxpayer charter is there. This taxpayer charter now gives responsibility that the assessing officer, the AO, will have to assume, will have to consider that the taxpayer is honest, impartial, and he should give accordingly a better treatment to the assessees. So based on this taxpayer charter, whenever we write it, the assessing officer knows, oh, this draftsman, this gentleman knows about taxpayer charter and he's showing me my responsibilities, so I should not act as high-handed. Or whenever the assessing officer is casually acting, again and again giving notices without proper time, or acting in a whimsical way, we should write this in our reply that we are inviting your attention to the initiative of Government of India, recognizing a definitely platform of taxpayer charter. So this paragraph, if we reproduced, these factors are very fundamental. And the assessing officer, we have practically seen in many cases when this taxpayer charter is given, the assessing officer start behaving in a better way. And whenever there is a borderline case, whenever we are citing taxpayer charter, the assessing officer is deciding in favor of assessee. Benefit of doubt is given to the assessee. So this taxpayer charter is also very important. Now, friends, uh, referring to verification team, whenever we play a table tennis game or a tennis game, what is the rule? We should not have any the ball in our court. The ball should always land in another party's court. So assessing officer, if is asking for books of accounts, if it is not possible and we are not submitting, then we should write that this faceless is a team based assessment. And since it is a team based assessment, we would request you to kindly refer it to the verification team. We will produce all the voluminous document before the verification team, let them verify it. Even after that, if the assessing officer does not refer it, which he rarely does, then in the case he cannot allege that what boss I have given the document you did not see. So the assessing officer will not have any argument against us. So whenever we get some this kind of notice, we should ensure that verification reference is given. Whenever we feel that we are not able to upload the documents online, we can refer it to the verification team. Then there is a old Hindi saying 100 baka ek likha. So 100 baka ek likha is always in a manner that what we are able to explain in a physical manner, we may not be able to explain in another things. So therefore, video conferencing might be opted by us. We should request for video conferencing. Then supporting, friend, whatever documents are being sought, we should give it. We should give extra documents also, what need may arise in that, but we should see what documents are not against us. So supporting documents is also very important. So facts, law, taxpayer charter, reference to verification team, video conferencing, so that phase by phase we can explain him the facts, and supporting documents. All these things are required to make a perfect draft for a powerful representation. Now, friends, you all have must read Srimad Bhagavad Gita. How Shri Krishna used to explain is a beautiful piece of drafting. I will explain you. Whenever we are making a submission before the EO, how do you start? When Krishna called Arjun, he used to refer him, Hey Parth, Hey Gudakesh, Hey Dhananjay. So different names he started giving to Arjun, so that these different names make a good appeal. It brings a good humor into it. So similarly, whenever we write to AO, respected sir is everybody writing. But if we want to make a good impact, you can write, may it please your honors, most respectfully Shivit, honorable sir. So this different kind of salutation must be used in our draft, which will make a good starting. Then, whenever we want to make an impact in writing, see, leave everything aside and listen to me. If we want to make an impact like this, you can start at the outset. So, leave everything and listen to this. At the outset, I would like to inform or submit. Then we write, this is regard to captioned appeal. Caption means subject. We always write with regard to subject appeal, but subject word is used by everybody. So, we can write captioned. This is a better manner to present issue. We submit as follows. Now, friends, there is an old saying, Saach ko aach nahi. What do you mean by this? Fact, truth has its own power. It will be a statement, and whenever we make a submission, it is a submission. So, when we are stating a fact, we have to write, we state as follows. And whenever we submit that, this exemption may be allowed. So, a request is a submission, and a fact is described, it is a statement. So whenever we write, we should make a distinction between submission and statement. These two are very important. Statement has more strength. Submission is a request to the officer. So this is the starting. How do we start each paragraph? How do we write a subject? How do we start with the matter? Then some special adjectives which are used in drafting without prejudice to above. For example, we have taken a legal ground and now we are coming on factual ground. So legal ground is not getting diluted by writing, making a factual submission. How do we ensure that? So first we have given legal submission. Now when we are explaining factual, we write without prejudice to the above, so that the aforesaid legal argument stands on the same footing and strength. Our giving a factual submission is just without prejudice. So this without prejudice to above should be written when some legal argument is there, and now we are giving a factual argument just out of abundant caution. Then, friends, many times it may happen that be that as it may. This is also a very beautiful line. What do you mean by be that as it may? That, okay, we understood you, but you see, still our point is valid from this way. So, how do we convey it to it? Here, be that as it may, even if you are okay, if you, even if you we accept your above contention, still on this ground we deserve a relief. Then many times something happens that there is a fact which is very common, but we feel we should repeat it, then we say needless to mention. This does not require to be stated. This is common sense, but still we are mentioning. So when this kind of impact or impression is to be made, we can begin it with needless to mention. Then if we want the AO to appreciate some fact, it may be appreciated that. Then whilst on the issue, while we are on this issue, you also listen to this way. So that is there. Then we are making a particular noting. It may be pertinent to note that this condition is compliant. So these are special drafting adjectives which may be used. Then when we are relying on some decisions, reliance is placed on the decision in case of so and so. The appellant relies on so and so decision. And when we want to highlight a decision that please see it carefully, then we write your kind attention is invited to the decision in so and so. So when we write like this, your kind attention to invited, then that makes a special impact. And then whenever we are writing a decision, your kind attention is invited to the decision of Bombay High Court in case of Reliance Utilities. It reads as follows. Then we should give the paragraph in indented manner. From left and right, both were indented so that it comes in between and it is in italics. And if we want to underline some line, we underline it and write underline for emphasis. By presenting a decision in this way, it is very easier to read and distinction can be made that what is our submission and what is the actual finding by the court. So that many a times what we may write, it may or may not contain that meaning. So exact finding of court may be reproduced so that the officer may read it himself and take a decision on that. So these are some different kinds of drafting words which we may use for making a powerful presentation. Then before concluding any submission, what do you want ultimately from this appeal? You have to pray for that. So it is always the appellant prays that the addition or disallowance may be deleted. In view of foregoing submissions, it is humbly submitted. Then whenever we are seeking something or something is there, we may thank the officer for this act of kindness. We shall always remain grateful to you. Then whenever we have submitted everything, but we want that if anything else is required, the assessing officer should ask it from me. So we can write, we hope that this fully explains the above. However, we shall be happy to elucidate further if need be. So, if you want anything extra, please ask us, we will be ready to provide. If we have written this line, then the assessing officer cannot say that I asked and the assessing officer, the assessee did not provide these details. So, these kinds of lines also make an impact. We can also request for a personal hearing. Then, whenever we are seeking adjournment, it is causing a prejudice to the AO inconvenience. So, whenever we are requesting for some time or adjournment, we should always end it with this line, hoping to be excused for the inconvenience caused. So, these are good drafting tools and techniques, friends, which we use to make a powerful presentation. Then, see, always pictures and tables have a better readability. Whenever we open a magazine, we may not read everything what is written in the magazine, but we may see all the pictures and photographs in that magazine. That is the important. So whenever we are making submissions, do not be shy in reproducing some pictures. For example, I am representing a shop owner or I'm making submission for a shop. So what I did, I took a picture of that shopkeeper in his shop and I stuck that picture to explain that he's a real businessman. There was a cash deposit in case of a Kirana shop owner. So to explain that there is a business, I clicked the picture and I pasted that picture in my submissions. Whenever there is a fact or some letter or some document, do enclose that picture in the submission itself. Reproduce it so that picture speaks louder than words. 100 words and one picture is almost equal. So you should give things in tables, facts, whenever you want, yet this thing should clearly come. Then put it in table format that this was, for example, assessing officer has made some allegation and we want to reply to that allegation. So averement, rebuttal. If you can see in the presentation, there is an argument, averment, and the rebuttal to that averment is there. So this way we can explain things point by point. Every argument, contention of the AO can be struck down in this manner. You write the argument and our reply to it. So this really helps in drafting submissions. See, always keep it concise. The longer paragraph you write, the lesser anybody is bound to read it. If you want to make readability, make it in points, shorter paragraphs, so that that increases the readability in any draft. So facts in tables, pictures, that really help in making written submission. Taxpayer charter we have already discussed. Some important pleading principles in powerful presentation. I'll come to the most debated issue, section 68 to 69D. In normal issue, whenever the assessing officer is making an allegation, the duty is on the assessing officer to prove that his allegation is correct. We are not required. First, the assessing officer who is alleging that you have very high income, on what basis is he alleging that we have high income? He has to give that basis. So the onus and the initial burden of proof is always on the party who is making the allegation. On the other hand, deemed in provision 68 to 69D, unsecured loan, unexplained investment, unexplained expenditure, the initial onus is on the assessee to prove the nature and source here. So this is also very important, friends. One more legal principle which we must appreciate: the assessee is never bound to prove the negative. For example, the assessing officer alleging you have income 10 crores, 100 crores. Boss, I am not responsible. You prove how it is income. So the assessing officer cannot ask me to prove that you don't have so much income. See, that onus cannot be done. If the assessing officer is making such attempt in his assessment order, show cause, or appeal, you can rely on this decision of Daulat Ram Rawatmal 1973 87 ITR, where the assessing officer cannot compel the taxpayer to prove the negative. What is apparent is real, has to be considered as genuine. So, assessee cannot be compelled to prove anything negative. Thumb rule: assessee is honest, he has acted in a bona fide manner. For 68 to 69D, this thumb rule is not applicable. Assessee is responsible to explain that whatever he has received is genuine. Whatever unsecured loan is received, it is not bogus, it is not unexplained cash credit, it is a genuine. And that can be explained by showing identity, credit worthiness, genuineness. For example, I have received something, a loan of 1 crore from a person. Who is that person? It may be so that I may give money to my driver and he deposits in his bank account and gives me check. No. First of all, there should be a person. Then he should have capacity to give loan to me. So there he should have credit worthiness, and the loan should be genuine. It should not be that I have given him cash, he deposits cash in his bank account and gives the loan to me. So genuineness, identity, and credit worthiness. These three things are very important whenever we are rebutting any presumption under 60 to 69D. Identity, merely if we show identity or file a confirmation letter is not enough. All these three ingredients are very important: identity, credit worthiness, and genuineness. Then circumstantial evidences, yes, they are important. Whatever are circumstances, there are two important decisions of Supreme Court, Durga Prasad Moore and Sumati Dayal, which says that in income tax, rule of evidence is not strictly applicable. If the circumstance also indicate that there is a tax evasion, then the addition can be made. But it should be indirect or circumstantial evidence. It should not be hearsay that some person has given statement that he lives a very good life, so he may have good money. No, hearsay evidence is not there. You should have some documentary proof and some circumstantial evidences which indicate together that, see, this kind of tax evasion or disallowance ought to be done. Then, friends, absence of witness. This is something very important. I have made purchases from a party last year. That party is now not in touch with me. What happened? Income tax department gave a notice directly to that party that please explain or confirm whether you have given this sales to me. That party did not respond. So my AO now says, See, you have said that you have purchased from so and so party, but that party did not respond to our notice. That means your purchase is bogus. Obviously not. I have made some purchases from some party. After making purchase and after making payment, I don't have anything more to control over that party. So, relying on this principle, Supreme Court, in the case of Anis Ahmed and Sons, 297 ITR 441, has held that mere absence of a witness could not lead to an adverse inference against the taxpayer. So, merely because the party from whom I have made a purchase has not confirmed in response to a letter issued by department, that cannot be ground to assume that my purchases are bogus when I am giving delivery challan proof and all the evidence is available with me. So, this is important. Mere absence of witness cannot be ground to make a disallowance in my hands. See, similar decisions, there was a Shale India decision. There may be several reasons for a party for non-appearance or non-compliance before the AO, for which this assessee cannot be penalized. That person, some other person is not responding to me. That is not my fault. I can do nothing in that case. So you cannot make a disallowance in my case. Then, friends, many a times we see that the assessing officer is passing the order in a haste manner without applying his mind properly. Application of mind is very important. So, whenever we are making a submission, we should ensure that wherever there are instances that there is a non application mind, we should highlight that instances and explain to the appellate authority, see, these kind of mistakes have been made by the O. So, therefore, he has not made proper application of mind and made this addition in a haste manner, which is unwarranted and uncalled for. Then, friends, many times it happens that assessing officer is relying on the basis of somebody's statement. The person may have changed the statement or he has given us confirmation, given some different version before the AO. In Hindi, we call him Dogla, a person who says something in one hand and something different in different. So that kind of Dogla person has no value in our society. Similarly, income tax, there is a decision Eastern Commercial Enterprises 210 ITR, where it is said that when a person is proved to be a shifty person as a witness, that statement of double speaking person, the findings of court, see how beautiful it is written. A man indulging in double speaking cannot be said by any means a truthful man at any stage, and no court can decide on which occasion he was truthful. When he gave a statement that he has made a bogus purchase, or when he has made the statement, nay, my purchases are genuine. When he said truth, you can never decide. So, merely on the basis of a statement of such kind of double speaking person, you can never make an addition in my hands. So these are very important decisions which will help you in making a proposition which is good in your case. Then, suspicions, merely on the basis of suspicion, no addition can be made by the assessing officer. This is a settled principle of law. A claim of witness cannot be rejected. There was a case, Shiv Narayan Dulishan. What happened in that case, that I called a witness, the witness came before AO and gave positive statement in my favor. Then the AO said he was your friend, so he gave the statement in your favor. Sorry, boss. Either you should not have called them. You cannot make allegation on suspicions. Either you cross-examine him. If he gives proper statement, that you cannot say that he had come to just please me or oblige the taxpayer. Lack of inquiry. I have given one submission. The assessing officer does not say anything. I give another submission. He says, Then third submission, nothing. He just sits back with folded hands and at the end says, I don't accept it, so I make this addition. Sorry, this approach is not acceptable. Our chartered accountant and retired judge of Honorable Delhi High Court, Sri R.V. Iswar, in the beautiful decision of Gangeshwari matter, they have said that the assessing officer cannot sit back with folded hand till the taxpayer exhausts all the evidences and then comes just to reject the same on the basis of presumption. So, lack of inquiry is something, if we find it, we should highlight it before the appellate authorities and say, cite this decision of Gangeshwari metal, which is very useful. Principle of natural justice. If time is not given to us, lesser time is given, then there is a lateral principle of audi alteram partem, that no person can be left unheard. So, opportunity of hearing should be given properly. See, let's be frank. If opportunity is not given, it is not that the order will be quite as such. the order will be remanded back and you will be given a fresh opportunity of hearing in those cases. So many times now what we see in CIT appeals, ex parte orders come. We did not come to know about the notices. We could not respond, and they have dismissed it uh, on the ground of non persecution. See, that is not permissible. And in such cases, we can go to the higher authority tribunal and request them that, see, opportunity of hearing was not given. And based on these principles of audi alteram partem, the case will be remanded back to the assessing officer again to give you proper opportunity of hearing and then make a de novo assessment. Independent private inquiries. Some person may say anything behind my back. What can I do? Assessing officer may go to my vendor and record any statement. That vendor is no more longer dealing with me, so he may give a statement against me. Whatever anybody else may say, that cannot be a ground for making addition unless what he has said is confronted to me. So first, whatever you can do an inquiry behind my back, but whatever you have gathered behind my back, if you seek to use it against me, you have to confront such evidence to me, as held by Supreme Court in the case of Kishan Chand Chilraram, and there is the old decision of C. Vasantlal. These two decisions, Supreme Court has clearly said that whatever third party evidence you have taken, any evidence or document from any place outside my premises, it is a third party evidence. You first have to confront it to me. If you have not confronted it before me, you can never make an addition in respect of that uh, unconfronted third party inquiry material. Then, once that material is given to you, then there has to be cross examination of such material. If a person says that I have given you my sales is bogus, so we will call him. How can you say, we will call him for cross examination? How can you say that this is invalid or this is bogus? Have we make you payment? Yes, you have made me payment. Have you given us the good? This is shown by the GST return. Yes, I have done it. So then we can cross examine him. See, practically 90% of the cases, department, due to its limitation, is not able to produce the witness for cross examination, and that is favorable to the assessee. But we should definitely ask for cross examination. Make a separate letter always requesting for cross examination in every case. Unless you make a request for cross examination, the assessing officer will never allow you from his own suo motu. So we have to make a request before officer for cross examination, and then only the opportunity will be given. Even in spite of making a request, if the assessing officer does not provide us the opportunity, then relying on the decision of Kishan Chand Chillaram and Andaman Timber, Supreme Court has held, then evidence which is not confronted for cross examination is not having any evidentiary value, and the cross examination cross examination material cannot be used to make any addition. So the addition may get deleted if the officer does not give you an opportunity to cross examine. Then, friends, many times it is seen that any pieces of paper or diaries or some things are found at third parties. See, frankly speaking, whatever you may write in a diary, it is a dumb document unless there is something corroborative. There is something which should show that nay, this is a genuine sign. Either it should be signed by both of person who are entering into a transaction. If both have signed it, then the document has some value. So this old decision of common cause versus Union of India Sahara Diaries case is a very important decision, which clearly says that loose paper, document, sheet, they have no value at all. These are dumb documents, so no addition can be made based on this dumb document. So this is a very landmark decision of Supreme Court. Almost everybody in litigation practice is aware about this decision. Common cause versus Union of India. So this decision can be cited whenever on the basis of third party inquiries some allegation of some transaction is made against you. Then WhatsApp chat. Whether any WhatsApp chat can be considered as evidence. See, WhatsApp chat now is considered as an evidence because see there is a acknowledgement that it has been received by that person, green ticks and all things are come. So therefore in court now even notices sent on WhatsApp are considered. Any WhatsApp chat is found, it is considered as an evidence. So these are very important things which we must be aware and be cautious of. Then I have taken a loan. The person who has given me loan does not have any regular income. So maybe he's an agriculturist and he has exempt income, or he has taken loan and given the loan to me. So merely if there is a low agricultural income, that itself would not indicate that this amount is not genuine. So these all arguments are made by you. We can rebut those arguments with the help of these decisions and this kind of propositions which we may formulate in our powerful presentation. Cash deposit before taking advancing loan. So it may happen merely because I have deposited cash cannot be a ground that it is my own money. So there are different decisions, and we can narrate the facts in the such a way to justify even when cash deposit is made, that is still a genuine payment. Whenever I am taking a loan and I repaid, that itself shows the genuine aspect. So, whenever there is an addition under Section 68, if the loan is subsequently repaid, repayment of loan is a very strong indicator to prove the genuineness of creditor. There are various decisions, Rakesh Bharti, HR Mehta. These decisions can be helpful to demonstrate genuineness of a transaction when it is repaid subsequently. Then, friends, whenever we are making a presentation representation, it should not be merely based on income tax, but allied laws are also very important. If you can see these three lawyers, these are greatest lawyers uh, who are considered in the practice of tax laws. And one common aspect, R.J. Kula, Sanat P. Mehta, and Nani Palkiwala, one thing which these three gentlemen have stated in their statement, their interviews, that they all started their practice with civil laws. First 3 years they practiced in civil law, then they adventured into taxation law practice. So, friends, this is very important that first we need to understand the important principles of other law, which will help us in making our presentation more powerful. These statutes, general clauses, Indian Evidence Act, Contract Act, Sale of Goods Act, Insolvency, Civil Procedure Code, these all are very important and helpful in even representation and income tax regime. Let's take example General Clauses Act. Whenever you have to decide a limitation issue, this General Clauses Act is a very important concept. ESIPF, we don't have any grace period. 15th is the last day to pay. If we have made a payment on 16th because 15th was a holiday, then 16th will be considered as genuine. We will get the benefit because of General Clauses Act, in spite of the fact that nothing is written in Income Tax Act. Then, if a provision is repealed, it is considered that it was never on the statute. This principle has been used in income tax also. For example, when the transfer pricing provisions were abolished, it was abolished, considered abolished from retrospective effect by various tribunals and courts, because domestic transfer pricing was abolished, because it was repealed. And when something is repealed, it is considered as per Section 24 of General Clauses Act that it is repealed from the date of its enactment itself. When the date of hearing is on holiday, you will automatically get 1 day adjournment because of General Clauses Act. So, friends, these different laws play a very vital role in making a powerful representation in the case of income tax. Indian Evidence Act strictly is not applicable, but how to read documents is also explained by Indian Evidence Act, which is important. Indian Evidence Act, how to read a document, assessing officer may apply it. This evidence law has very important aspects which would be very relevant in tax practice. I'll explain. Indian Evidence Act is not applicable, but when department itself in their manual for survey and search have used Section 65B of Indian Evidence Act, that whatever electronic document you get, you have to give a certificate under Section 65B4 of Indian Evidence Act. I'll give you an example. There is a survey on some party. He is a builder. From his premises, an Excel sheet is recovered. That Excel sheet contains names and details of some alleged on money. Now, based on that alleged on money Excel sheet, the assessing officer is now asking me, as a buyer of that property, to offer that amount in my return of income. I will say You are relying on an Excel document, which is the electronic record, and that electronic record can be admissible against me only when you can give a 65B certificate. In a case of Polisetti Somasundaram 2023, Vishakhapatnam Tribunal specifically held that this electronic evidence should be accompanied by 65B certificate. Since this was not followed, the information contained in the seized pen drive cannot be considered as an admissible evidence. It cannot be considered. So, Indian Evidence Act Section 65B useful in income tax in defending your case. So, these other laws have wide implications. Common cause versus Union of India. This case also, Indian Evidence Act was used. Section 34 of Indian Evidence Act was relied here. Then, friends, now how to use civil procedure code in making a powerful presentation representation. See, whenever assessing officer wants some details from us, he will give us summon under 131 or 133.6 and extract that information. So this is a sword, but a double-edged sword. How can we use it against the department or against to defend our case? I'll explain. I have made purchases from a party with whom I am no longer in talking terms. I will ask him, the assessing that party will not give any detail. Assessing officer is asking me to give confirmation. In such kind of cases, we can give the details of that party, statement copy of that party to the assessing officer and request the assessing officer to request and ascertain these details through summon. There are various decisions, Prakash Chanata, Madhya Pradesh High Court, EMC Works, Allahabad High Court, Continental Steel, Delhi High Court, Delhi Tribunal, where it is clearly held that when you can also request the assessing officer to exercise the powers vested in 133.6 to conduct inquiry from a person. So if I cannot get any details, or if I have taken local loan from a person, if I am asking, please give your bank statement also, he will say, I will never share my bank statement to you. So then I will request the AO, you take this details directly from the person. These are his contact details. Once we give it and we request the assessing officer to write to request for someone, then even if the person does not give it to us, we will not be prejudiced. We have asked assessing officer, if the assessing officer does not call details from him, then he cannot make any addition in our hands. So these tools of civil procedure codes are also very important. We can request the assessing officer to write to request for summon for our proceedings. Then, if I am staying in Delhi and I am getting a notice from Bombay, I cannot go to Bombay. So I will request the AO in Bombay to give commission. Commission is basically a letter requesting to take the statement. So I am a person resident of Delhi. Inquiry is going in Bombay. So the Bombay AO will request Delhi AO to take statement from me. So whenever it is more than 500 kilometers, this is a very important thing beyond the limit of jurisdiction, that you don't need to go to such place so far. You can ask that person to issue a commission so that you can give a statement before your jurisdictional assessing officer in your own town. So this power to commission is also a very important tool used in appellate and representation proceedings. What happens when you violate other laws? See, I have given salary in cash and not complied with PF provisions. So does that make it a bogus salary? No. There are various authorities which say mere non-deduction of PF or merely because the assessee has not deducted PF or salary is paid in cash does not make call for a disallowance here per se. If the cash payment is less than 10,000, I am not deducted PF, but I have details. So then merely because of non-compliance of PF or ESIC, or if that revenue stamp is not there, all these grounds cannot result in disallowance under income tax. If I am not complied with PF law, you go and levy penalty under PF law or stamp duty law, or labor department will levy penalty on me, but you cannot make an addition against me in income tax because of non-compliance of any other law. There are various decisions which I have shown here. One very important principle we have been listening since age-old days: ignorantia legis neminem excusat. Ignorance of law is no excuse. But friends, let me tell you, Supreme Court in Motilal Padmapat Mills has said that it must be remembered that there is no presumption that every person knows the law. So this presumption, ignorance of law is no excuse. Itself is not a valid. Supreme Court has not accepted it. It is often said that everyone is presumed to know the law, but that is not a correct statement. There is no such maxim known to law. This kind of maxim was there in Greek Latins, where Romans used to rule, and it was said, "Na khata na bhai, hum jo bole wo sahi." Whatever the king says is the law. That time, this kind of principles were there. In today's time, democratic time, this ignorance of law is no excuse. Itself is not something acceptable in law. Then, friends, this principle that there is no such maxim known to law has been applied in the case of CIT versus Biju Patnaik, 112 ITR. 143.1. We have seen maximum 99% assessments are done in summary manner through 143.1. And what happens that when we do this, many times it may happen that the processing is wrong. So we have a good option. Go into your income tax portal services rectification and reprocess the return. You press it. If any erroneous proceeding has been done, it will automatically get rectified therein. Right, sir? Then, even if 143.1 something is there, then you can you have offered something erroneously in your return of income. Later on, 143.1 has come accepting your return. You can still challenge 143.1 that assessing officer has not given credit of something which was not chargeable to tax. So you can take a fresh claim in appeal filed against the order of 143.1 also. Friends, there is a very important principle that AO has to give physical notice if assessee's email ID is not available in PAN database. Many times he uploads on portal, but that is not enough. Portal should be updated, and we should avoid using our ID as primary ID, because what happens, communication should always be secondary to us. It should be first go to the assessee. Otherwise, what may happen that if you have not responded, or there are scenarios when notices have come to you but you have not informed the client or not responded, and there is an ex parte order, then the client may complain against disciplinary proceedings for gross negligence. I have seen many such cases against many members where, because of ex parte orders, clients have gone in important matters against the CA in disciplinary mechanism, said that the member is grossly negligent because he received the notices but did fail to reply. He did not reply to those notices. So this is also important, that we should have secondary ID, and we should check the portal time to time and use the tools and techniques. Which tools are there? Notice alert kind of softwares are there which update you about any notice came in your client's case. See, this is a very important principle of 1955, circular number 14. This says that if assessee has offered something wrongly in his return or failed to take a deduction, then the officers of department must not take advantage of the ignorance of assessee and explain that this is your right and assess the income correctly. So AO should assess fairly, giving credit in spite of the fact that assessee has not claimed it. So this is the principle based on which, if something has happened and assessing officer has not fairly granted a credit or has taxed something which was not taxable, then we can go in appeal. We have all rights in going into appeal. See, there was a decision, Goits India, that AO, before AO, you cannot take a revised claim, you have to file revised return. But nowadays, it is not possible to file revised return. So, in that case, that scenario, it is always advisable to take a fresh ground of appeal, fresh plea, fresh claim in the appellate proceeding. Supreme Court, in the case of NTPC, has allowed that fresh grounds can be taken in the appellate authorities, appellate forums. Condonation. Friends, many appeals are filed in delay. So it is a settled law by Supreme Court in case of Kardji and others, collector land acquisition, that appeal has to be decided on merits and should not ideally be dismissed on technical reasons in the interest of justice. So the appeal should be decided normally on the merits of the case, which should be ensured. Ex parte orders. There may be many reasons. You should explain properly whenever you are filing an appeal. Call the client, and the client may be requested to narrate the facts, and from that you can get a good set of facts based on which you can say that because of this reason the order is ex parte, and therefore we may request that this ex parte order may be set aside and we be given a fresh opportunity. So ex parte orders may be there, but and now very good amendment has come. Friends, please note, if you have assessment order which is best judgment 144, you request to the CIT appeal to remand it back. It can be set aside to the assessing officer. Powers have been given to the commissioner of appeal to set aside all such cases where best judgment assessment under section 144 has been done. So this is important. We must note it. Many times, friends, it happens that there are delays in filing audit reports or any document. For example, in case of trust society, 10B is filed late. So these are directory provisions, and mere delay in filing cannot result in disallowance. There are various decisions that, okay, there is a delay, so you request for condonation and file the appeal. If it is if your reply is filed before assessment or before appeal, you may get relief in appellate authority. So merely late filing of form 10B or any other form is not a strong ground to disallow your exemption. So therefore, whenever you see such kind of 143(1) or such kind of orders, you may file an appeal. You can ensure that your form 10B is filed, though delayed, but it should be filed. Once filed, you have very good ground to defend it. ATP. This also requests, now there is an amendment where it said that if return is filed delayed, ATP deduction will not be given. There are various tribunal decisions. Firstly, we should ensure that these are timely filed. And if it is not filed, we can request the commissioner for condonation and also file an appeal against such delayed disallowance. So there are various decisions that merely on ground of belated filing of return, disallowance of ATP is not justifiable. Kerala High Court decision, Chirakkal Service Cooperative, Lunidhar Seva Rajkari Mandali, Rajkot, and these decisions are there, which will be really helpful to all. Then, friends, some very important case laws which are important to be discussed. Just a minute. Yeah. Is it visible? Some important case laws which should be considered while appeal. Bajaj Tempo. The Supreme Court decision 196 ITR says that whenever there is a deduction or exemption provision, it should be interpreted liberally. So if we are discussing an appeal or filing a representation in an appeal for 54 or such kind of deduction exemption provision, we can cite this decision which says that a provision in taxing statute for promoting growth or development has to be construed liberally. Otherwise, the provision will get frustrated. So after making our submission, this appeal to liberally interpret the provision should be done, which will again give us strength, will make a mindset and background of the appellate authority in deciding your case. Otherwise, these interpretational provisions are very important. So whenever we want a relief and our facts are weak, then a legal appeal that how to interpret this kind of deduction exemption provision is explained in Bajaj Tempo's case. Then there are two views. One view is favorable, one view is against. What would prevail? So whenever there are two views, the view to favorable to assessee will prevail. Whenever there are two decisions of different high courts and no jurisdictional high court, the high court decision which is favorable to the assessee shall be prevailed. This is a very important principle laid out by Supreme Court in the case of vegetable products, cited in 88 ITR 192. So this is important. These important decisions have changed the litigation. Then it is an important thing that substance will always prevail over form. So Travancore Sugar decision 88 ITR 1 Supreme Court that it is the substance which has to be prevailed over form. And whenever we are reading the agreement, it should be read as a whole and not in piecemeals. So this is important. Whenever it is Gessner's decision, if there is a CBDT circular, these circulars are binding on department and never on the assessee. If it is favorable to department, they are binding on the assessee. If it is favorable to the assessee, it is binding on department, but it is never binding on the assessee. So if the circular says saying something, merely because of circular, our benefit cannot be denied. A circular is never binding on the assessee. If there is an order of tribunal and the AO is not listening, then we can cite this decision of Agarwal here, warehousing, Madhya Pradesh High Court, where strictly it is said that orders passed by tribunals are binding on all authorities functioning under the jurisdictional tribunal. The reason being that hierarchy has to be maintained. You have to listen about the orders, instructions of your higher authorities. So this is a very important decision on rule of hierarchy. Then last year my claim was allowed on same sex. This year AO says no, I will not allow it. This cannot be entertained. Supreme Court in the case of Radha Swami Satsang has very beautifully cited that whenever there is a consistency, rule of consistency should be followed. If last year the AO has accepted something on same facts and there is no change in fact, then rule of consistency ought not to be violated or not to be break. You cannot change a position in next year without challenging the order in previous year. So it should be appreciated that rule of consistency is important. And whenever we are citing about rule of consistency, we must definitely cite this decision of Radhaswamy Satsang versus CIT 1992 193 ITR. A very important decision on rule of consistency must be followed. Then, friends, many times AO may encast you with a condition which is impossible. So we may cite the decision of LIC versus CIT, where Supreme Court has said that assessee cannot be compelled to do something which is impossible for him or beyond his control. Then whether there can be double taxation. So there is a decision of Supreme Court in the case of Nagappa versus CIT, where it is said that there cannot be double taxation. This principle firmly eschews double taxation. So whenever you see there is a double taxation, you can cite the decision of Nagappa versus CIT. Many times it may happen that some notional income is being added to your case. Supreme Court in very clear words have written that it is the real income which can be subjected to tax. Income tax is a tax on income and not on notional income. So Shurji Vallabh Das is a very important decision which clearly lays down that real income can be taxed. So many a times when absurd results come, whenever some high pitch additions are being made, so these cannot be made addition to the income of the assessee. Only real income can be subjected to tax. This is very good, firmly propounded by Supreme Court. Then, friend Kishan Chand Chillaram, we have already discussed that unless confronted material is given to us and that party is produced before us for cross-examination, that evidence is not reliable. In Sunita Dadda's case, Supreme Court, it was a very beautiful decision where originally AO did not give opportunity for cross-examination. In appeal, the AO said, now give me opportunity. So it is held that department cannot be given a second chance to rectify its mistake. So you should have given in the first instance the opportunity of cross-examination. If it is not given, you cannot be given that opportunity again and again. Many times there is a dispute of year of taxability. We are offering in 1 year, department is saying no, it will tax in earlier year or subsequent year. So it is very beautifully laid down by Supreme Court in Excel Industries and Bombay High Court in Nagari Mills. Department should not fritter away its energies in raising questions as to deductibility or taxability. It should not dispute something when ultimately it is year. If the rates of tax are same, then department should not waste its energy. So these two decisions, Excel Industry and Nagari Mills, are very important when year of taxability is considered. And whenever there is a dispute of year of taxability, there is a decision on case of Manilal Tarachand, where it is held that no penalty can also be levied when you have offered income in 1 year and the same has been taxed by department in another year. Department cannot levy penalty when the dispute is merely year of taxability because no income has escaped assessment. Then, friends, when does an item become income? It is said to be income when the right to receive is vested in your hands. Then only it is income. Otherwise, it cannot be said to be income. Right? So this is a decision of Supreme Court in the case of E.D. Sassoon that when does the item become income? When the right to receive is vested in your hands. You may receive it, but you may have to return it. So when it is risk and rewards are significantly transferred and the right to receive is vested in your hand, this is a landmark decision of Supreme Court way back 1954, 26 ITR. But it is still very much relevant in today's times. Then, friends, one of my favorite decision is Dhakeshwari Cotton Mills, that no addition can be made based on conjectures and surmises, pure guess and assessment. Any addition can be made only when department has strong evidence to make that addition and not merely on the basis of conjectures and surmises. Then there is a decision of Supreme Court in the case of SA builders. Friends, this is also a very important decision where it is said that you have to think from the perspective of assessee. Department cannot do business. They don't know how to do business. They have to think, enter into the shoes of the assessee and then decide. The department cannot justifiably put themselves on the armchair of businessmen and say that this is reasonable, this is not reasonable. It has to be seen from the perspective of assessee. SA builder is a very important decision of Supreme Court. Then, friends, whatever is the treatment in books of accounts, you may write something which is not income as income in your books, but that will not make it income. Treatment in accounts is not determinative of deductibility or otherwise. Same way, Kedarnath Jute decision is there, Supreme Court. Treatment in books of accounts may not make it income in the hands of assessee. So these are very important principles, friends, which we need to take care. Wholly and exclusively, section 37, this expression is there. So wholly and exclusively does not mean necessarily. So this is also a very important principle. Supreme Court decision Sassoon J. David is there. So these decisions are those decisions which have made the law. So, friends, we need to be aware about these decisions and use all these principles and decisions while making your drafting, which will make your draft a strong one. Some important, see, friends, in faceless regime now, show cause notice is very important. So, some important principles of show cause notice also we will see. Mere letter or communication asking for payment is not a show cause notice. So, you cannot consider these decisions are there. Show cause must be in writing. Oral show cause is not valid and it should contain all the essential details. Show cause issued under a wrong provision is not valid. Correct show cause under right provision should come. You have to analyze the show cause. You have to read from date of issue, date of receipt, what are relied upon documents. Friends, 148 now is coming without relied upon document. What is the basis based on which you have issued 148 should be given along with the notice itself. So if 148 is given without relied upon document, it is null and void. So these are important things. Statement, if it is if documents are in some different language, then free translation should be given. What are the facts should be clearly given. Allegation, what are the nature of allegation, basis of allegation, you have to give your evidence, facts, then interpretation of the provisions, judgment, technical report, third party statement, cross examination, corroborative, board circulars, if revenue appeal is pending. So all these charges, this is a preparation of defense against any show cause notice. Whenever you make a reply, first give backgrounds and statement of facts, brief background, then narration of facts, chronology of events, relevant fact, exhibits, whatever document you are given, do proper para and page numbering, amount of text involved, and gist of allegations. Then grounds of defense, then merits. Limitation period is something very important. So merits of cases, facts, then limitation grounds, computation aspect, whether they have made calculation properly or not, and penalty notices if given should be asked to keep it in abeyance. So these are very important. Friends, fair and reasonable hearing is very important. Whatever order you are getting should be reasoned and speaking order. Order cannot go beyond or contrary to the show cause notice. Officer can never review his own order. Some do's and don'ts I will discuss. You have to note the date of receipt, date of issue, give an acknowledgement, check all relied upon documents which are written in the show cause notice are given to you or not. If not given, ask for them. Ask for free translation if the statement is some other language. And these kind of things, I will share my presentation with you. You ensure that your wakalatnama and authorization is there. Whenever you are appearing in video conferencing, wear a tie or coat. Always make your own short notes. What are the executive summary points which on which you are going to argue? Friends, always speak slowly, softly, clearly, and do maintain decorum. Whenever I am arguing before a court or making submissions, before starting to argue, I always drink a glass of water. That is very helpful, friends, because we need to ensure our health also, mental health also, when we are dealing with this kind of things. Some important don'ts. Never address the officer by his name. The order or notice may bear his name, but you have to address it to the position, to the income tax of the range number so and so. Always write honorable or respected. Never seek adjournment on flimsy counts. Don't use harsh or abusive languages. Whenever you are relying on a decision, don't go by head notes. Don't be shout or hysterical in the court hearings. Do not make irrelevant submissions or state irrelevant facts. Don't try to impress your client by arguing a case, and never copy and paste your pleadings. This is not correct and this will not give a proper view. So, friends, these were some important do's and don'ts in the appellate proceedings, which I have tried to discuss before you. Uh, Friends, well begin is half done. So, it is always important that how we make representation in these proceedings is something very important. Any doubts, any queries on representation? My presentation is very long. Um, I'll share my presentation with all of you, friends. So, do and any queries or doubts can be displayed and we can discuss it with you. My details for any query are there before you. You can text to me or send a mail to me on pankajjisha@gmail.com. Right, sir? My number also you can note 96918 93040. Any doubt, queries, my presentation will be shared with you. If anything is there in chat box, we can discuss it.
Yes, so there are some queries raised by our participant
Yeah, I
CA
cannot
members.
see in the
No, no,
people's.
not you cannot find it in the chat box.
Yeah, please.
Yeah. So one question from CA Mudassar Bareli. An appeal has been filed before CIT appellate against an order of AO under section 147, read with section 144 of Income Tax Act, where AO has passed ex parte order due to non participation by the assessee. Ground of appeal has various technical ground, and but CIT appellate has not disposed any ground but refer the case back to the AO filed against section 251(1)(a for fresh assessment. Now case has
Absolutely
been
right.
reopened.
Yes. Whenever order is passed under 144, now CIT appeal has got a new power to set it aside to the officer. So he has correctly done so.
Okay.
Yes.
Next question. Two CA members have asked similar type of question. One is CA Kishorlal from Pune and one is CA Madan from Mumbai. If AO, without considering our submission, passes ambiguous order, shall we go for appeal or for rectification of order? Is there any other way to represent?
Both. See, you must file a rectification if any vague things are there, and we must also file an appeal in this case. These both are important, and if you file it absolutely vague, you can also write to the high pitch committee which is made by the government. That is also very much advisable. So all
Okay.
remedies should be utilized. We should not only go by one front. Whenever we are at war, we are fighting it from all the fronts. It should not be only one front. Otherwise, the enemy may surround you.
Perfect, sir.
Right.
Next question, very practical. CA Jaswinder from Firozpur. Kindly, sir, discuss the circumstances in which physical hearing could be granted by faceless system in assessment as well as appeal.
See, physical cannot be, video conferencing hearing can be given. Physical is we cannot.
Okay. Uh, Next is CA Sanjeev from Kota. He is asking, we do not have received any order from CIT appellate even after considerable time has elapsed from date of filing of submission. Then after few months,
Yes,
we
this is a
are
practical problem.
receiving,
Huh.
yes.
See, if there is an urgency, we can file a petition before High Court, and the High Court is normally directing in many cases to dispose the appeal at the earliest. But otherwise, we can just request the CIT appeal in normal manner to fix the hearing and decide the matter at the earliest. But it is difficult. It has not been done in many times. So High Court, if there is a high stake matter, we may approach directly to the High Court, and the High Court may give direction based on which the faceless AO CIT appeal may decide it at the earliest. But now there is a movement. Even institute has represented from department also. There is a news that they are going to expedite the disposal of old appeals now, because now VSVS is over. Vivad se Vishwas is also over.
Okay. CS Shivaji Prasad from Vijayawada is asking, for preferring appeal, 20% of demand tax has to be deposited. But is there any other procedure to go for appeal
See, first of
without
all,
this
let me clear
20%?
this assumption. For filing appeal, 20% is not mandatory. You may just have
Okay.
to deposit 1000 rupees challan and you can file appeal before CIT appeal. It is for stay. So if there is no money in your account, there is no need for stay. For automatic stay, this 20% requirement is there. For filing appeal, nothing is required.
Okay. Next is there any time limit for completion of assessment under faceless scenario?
Time limit for appeal?
Yes.
No, there is no
Time
time
limit
limit.
for completion of assessment.
Assessment, there
From
are different time
completion
limits
of
given.
assessment from our submission.
See, time limits are given in section 151 and 149. Normally, it is 21 months. So, say 31st March for the from the next year when you have received the notice. 1 year time is normally given.
Okay. दुबे सर फ्रॉम अहमदाबाद पूछ रहा है कि सर कैन कंडोनेशन ऑफ डिले अंडर सेक्शन 1192B इज जनरली ग्रांटेड अज्यूमिंग दैट असेसी इज इलिटरेट.
Yes, we can apply, and if the CIT appeal is CIT is convinced, he can grant it. If he may not grant it, you can approach the High Court, and the High Court may be pleased to grant because this is a benevolent thing. So they may grant you.
Okay.
It is all about
Sir, so
representation. See, how do you present? If you make your case before the CIT, he would be happy to grant you.
right. So few questions are regarding cash deposit. Let me brief it. Someone has asked कि अगर कैश डिपॉजिट किए हैं 3 लाख 3 लाख रुपीस और वो उनके सीनियर मेंबर से मिले थे, मम्मा या पापा के मेडिकल ट्रीटमेंट के लिए उन्होंने इकट्ठे किए थे एंड दे डिपॉजिटेड इन द बैंक एंड फिर इनकम टैक्स से नोटिस आती है कि इट इज अनएक्सप्लेन्ड मनी, तो उस पे
सो
इंटरेस्ट वगैरह
जो
वगैरह
भी
लग रहा है.
सोर्सेस थे उनके, जो भी
हम्म.
सोर्सेस थे वो एफिडेविट से एक्सप्लेन करें. अगर किसी से लिए थे 20,000 से कम तो वो एक्सप्लेन करें. किसी से गिफ्ट डोनेशन किस रूम में कैसे उन्होंने वो किए थे, या अगर पुराने 10 साल के इकट्ठे उनकी सेविंग्स हैं तो हर साल की रिटर्न इनकम कितनी थी या सोर्सेस क्या थे उनके, अगर टैक्सेबल इनकम नहीं थी, वो पूरे फैक्ट्स को ग्राउंड बना के आप प्रेजेंट करें तो आपका 2.5-3 लाख रुपए में तो कोई प्रॉब्लम नहीं आएगी एक्सप्लेन करने में.
Okay. Question from Raigad is, one client has received notice for 148 and submission done based on the requirement and filed income tax return and audit report for delay caused due to beyond the scope of assessing. Now AO decided 10% of profit from business as per audit report and deny our submission and pass the assessment order. Hereby AO not considering any submission from the client side and pass the order as they think fit. Constraint
See,
second.
Dhakeshwari Cotton Mills Supreme Court decision is there, which clearly lays down that they AO cannot make such addition on conjectures and surmises. So this kind of, if treatment is done by the AO, it is not acceptable and would be quashed by the appellate authorities. Dhakeshwari Cotton Mill is a very good decision, and this kind of ad hoc taxpayer charter, which I have explained in my presentation, will also be helpful for members to refer. The taxpayer charter should be reproduced in this kind of cases before the authority.
Okay.
Right?
Next question is from Sanjay Jain, Delhi. During submission against Shoko's notice, valuation of gold was explained on weighted average method, which was consistently followed in preceding years. Ad hoc 5% addition in the closing gold stock was made on plea that bring the same to the market price on 31st March 2023, overruling the accounting principle standard AS2. Please suggest.
See, he cannot do so. Rule of consistency
Okay.
we can rely upon, and Dhakeshwari Cotton Mills ki no conjecture, surmises or ad hoc additions can be made. And we have to, there is a decision of Uttar Pradesh State Transport where it is held that accounting standards must be followed in ascertaining the business profits. So cost or NRV, whichever is lower, they may also rely upon section 145, which also lay down an ICDS 2. All these income tax precedents and authorities also lay down that any valuation of inventory has to be done at lower of cost or NRV. So if any gold stock is there, it has to be valued at cost, weighted average cost, irrespective of its market value.
Got it, got it. Question from Ahmedabad. Got a Shoko's notice
How many
under
more
two.
queries are there, ma'am?
Sir, just last question.
Yeah,
Let me
tell me.
take this question. Yeah. Got a showcase notice under 270A by 24th Feb 2025. Means it's a current showcase notice. Submitted fact and evidences and affidavit also. Again got the showcase
Hmm.
notice to submit by 30th May as previous reply was never submitted. Compelled to resubmit. Is it normal from AO or do we commit
Yes, it
any
is
other?
normal because these notices are generated on a click of a button. In case of all the clients, such kind of notices are there. So we may ensure that when this kind of practices are there, you again submit the reply or refer to the earlier reply. You should always reply, submit that the response has been made in response to the hearing notice dated so and so.
Okay, wonderful, sir. All the questions are answered, I guess.
Thank you
Uh,
very much for providing me this opportunity to discuss this important topic with all the members.
Wonderful. Sir, I must say over 1500 viewers are there. So 1500 CAs are listening to you. And most of the participants have asked your PPT. As it has
Definitely,
covered all the points. Yes, sir, you need to send it through mail.
we will share it to members.
So here I see Brinda Vakharia, chairperson of Bharuch branch, pleased to thank our faculty of today's session on faceless assessment, CA Pankaj Shah for briefing us in a very understandable tone. Sir has also mentioned how Krishna has used to uh, offer, like he has done very nice comparison how we should honor our income tax affiliate or commissionerate. So wonderful, sir, wonderful coverage, and you have covered almost everything with excellent PPT, sir. That's why our CA members are asking for your PPT. Thank you so much to Direct Tax Committee of ICAI for presenting such a valuable webinar to our CA members. Thank you so much, everyone.
Thank you. Thank you so much. Thank you. Thank you, ma'am. Thank you.
Thank you, sir. Thank you, ma'am.